We're back on the record, and up next we have People v. Terry Springer. It's file 26-7162FH. Counsel, you want to state your appearance, please?
Melissa Goodrich, Wayne County Prosecutor.
And James Gilbert here on behalf of Mr. Springer.
All right, and this is up for docket call. What's our status here?
Your Honor, the prosecutor and I are working on a plea potentially, and Mr. Springer's been involved in that. However, we have not come to a resolution at this time.
Okay. We continue it to the July 7th docket at 2:40. And so we'll go ahead and so that'll be, let's see, July 7, 2:40 in the afternoon, and we'll have that be plea and motion cut off as well then.
Perfect.
All right, anything further on that file?
No, Your Honor, thank you.
Okay. We're all set.
Yeah, no, she has nothing to do with you.
All right, next we can call People v. Carly Hurd, file 24-6787FH. And we're here on a probation violation hearing. And Mr. Gilbert, do you know how she wishes to proceed?
Yes, Your Honor. Her and I talked yesterday, and she wishes to plead guilty to not reporting.
All right, Ms. Hurd, would you, as best you can, raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help God?
Yes, sir.
Put your hand down. Ms. Hurd, you understand you have the right to have a probation violation hearing with the assistance of a lawyer and to question the evidence presented against you and to present evidence in your own defense. You understand those rights?
Yes, sir.
You're on probation for possession of a controlled substance on a 7411 deferral. If I find you to violate your probation, I can revoke the deferral, can revoke the probation, and the maximum penalty is 2 years in prison. Do you understand that?
Yes, sir.
You'd have the right to the hearing where the prosecutor would have to prove that guilt by a preponderance of the evidence. Do you understand that?
Yes, sir.
Has anybody promised you anything in exchange for your admission?
No, sir.
Has anybody threatened you?
No, sir.
So you're on free choice.
Commentary vo. Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. At first glance, this might seem like a routine probation hearing, but don't let that fool you. A guilty plea doesn't automatically mean the outcome is predictable. The judge still has broad discretion when deciding whether to continue probation, revoke a deferred status, or impose jail time. Every answer from this point forward matters because the court is evaluating not just what happened, but whether the defendant is taking responsibility. Watch closely. This hearing could end with a second chance, or with consequences that permanently change this defendant's record.
Yes, sir.
Knowing all this, how do you wish to plead to violating probation? Guilty or not guilty?
Guilty.
So, Ms. Hurd, were you on probation to this court on a 7411 for possession?
Yes, sir.
And as part of that, were you required to report to the probation department as instructed?
Yes, sir.
Did you fail to do so back in October of 2025?
Yes, sir.
And then did your failing to report extend for at least a 60-day period?
Yes, sir.
Okay. All right, meaning you were failing to subject yourself to supervision for longer than 2 months. Is that right? Okay. Mr. Gilbert, you satisfied with that factual basis?
I am, Your Honor. Thank you.
Ms. Goodrich?
Yes.
Are you aware of any other promises, threats, or inducements, Mr. Gilbert?
I am not.
Ms. Goodrich?
No, Your Honor.
All right, Ms. Hurd, I find that I'm going to dismiss counts 2 and 3 and find that your plea to count 1 is knowingly, understandingly, and voluntarily made, and that there's a sufficient reason in fact in law to find that you have violated your probation, and I would make that finding. Mr. Gilbert, any objection to waiving any probation violation report and proceeding to immediate sentencing?
No objection at all. Thank you.
Any objection from the people?
There you are.
Mr. Gilbert, go ahead.
As the court is probably aware, there's other cases pending that my client has to deal with, and we would ask that, and she understands that her deferrals is most likely going to be removed, and she will not get the benefit of that. I really wish she would have. However, I would ask for the court to consider time served and remove her from probation as unsuccessful.
All right, thank you. Ms. Hurd, you don't have to tell me anything, but you're welcome to. Is there anything you want to say today or no?
Just that I'm placed right back on probation for the county that I'm going through, so.
Well, I hope you have better success there than you did
Yes.
here. Okay. That's up to you, right?
110%. I was the same probation officer. Me and her had a long conversation. I'm due to meet with her tomorrow at 1 o'clock. She doesn't want time to work. I have time to negate my responsibilities, as she worded it, and
Okay.
I have a job, so she's willing to work with me, and I have my cases PR bonded
Okay.
with her approval to be able to. That's all. Thank you.
Okay. Thank you. Ms. Goodrich, any recommendations from the people?
Yeah, Sharon, thank you. It sounds like they're willing to give Ms. Hurd a second chance in Ogama County. I hope she takes advantage of that. For this case, I would ask for the 7411 to be revoked and her discharge is unsuccessful with credit for time served.
All right. Well, Ms. Hurd, if you were, I mean, your compliance with probation, to me in this case was really terrible. And so if you were on probation to me for a higher level felony crime, you'd be looking at some serious jail time or maybe even prison. So I hope you comply with probation down in Ogama. But what I've got you on probation for is possession of Xanax. So we're not gonna send you to prison on that with no prior felonies. So I will find that you have not complied with the deferred status or your probation. So I'm going to revoke the 7411 status and revoke your probation and discharge you as unsuccessful from probation. So then we're going to enter a judgment of sentence on that felony possession charge. There's $68 in state cost, $130 in a crime victims assessment, $350 in court costs, and $60 for DNA testing fee. That'll remain due and owing in the amount of any unpaid balance. And I'll order that you serve 64 days in jail and give you credit for 64 days that you've already served on this violation and on the initial arrest. So because we are entering that judgment, I'm not going to continue on probation. So as soon as we get that paperwork done, you'll get released. You'll have to make arrangements to set up a payment plan to take care of these fines and costs.
That's part of my court case on there. Since she's is the same probation officer and knows what had happened and knows that I'm the one that is signing her, she has it set up to where I have to have that as part of an agreement to be able to pay this and clear court cases and show that I'm making progress to do outpatient, at least rehab outpatient services.
Okay.
Due to being a heavier felony.
Because we are entering the judgment, you can appeal if you wish by filing an application. So we're going to hand you a piece of paper explaining that and ask you to initial one copy for us so that we have a record we gave it to you. It's about your appeal rights. If you want a lawyer, you'd have to ask me within 6 months. Where'd you get that?
It's on judgment.
Oh, okay. She's allowed to have that. Okay. All right. I just see her pull a pen out. I wanted to talk about it. All right. And the other one is for you to fill out if you want to file an appeal. Okay. Good luck to you, Ms. Hurd. In the record, and we'll call people be Christopher Jolette. It's two file numbers 22-6490FH and 23-6535FH. Counsel, you want to state your appearances, please?
Yeah, thank you, people.
And James Gilbert here on behalf of Mr. Gillette.
All right, and Mr. Jolette is here for sentencing on probation violation in both these files. And we had waived the preparation of a probation violation report because Mr. Jolette has his case in Emmett County is a bigger problem for him than these 5-year felonies here. So, Mr. Gilbert, do you still continue to waive preparation of a PBR?
I do.
Mr. Joliet?
Yes, I do.
All right, Mr. Gilbert, anything you want to say in your client's behalf?
Your Honor, I believe Mr. Gillette has served a considerable amount of time. And now that he's pled over in Emmett County, as the court has identified, that's a bigger fish to fry for Mr. Gillette. I would just ask that he be removed from probation and sentenced to time served.
All right, Mr. Joliet, you don't have to say anything today, but you're welcome to. Is there anything you want to tell me today or no?
Just that I'm sorry, Your Honor. I deeply regret my actions, and I have a long road ahead of me. But I do plan on seeking out any and all resources available to me, and to get the help I need and to better myself overall. So,
All right, thank you. Mr. Juliet, any recommendations from the people?
I agree with what Mr. Gilbert.
All right, thank you. Well, Mr. Joliet, obviously, when somebody's on probation for theft-related offenses, it's our hope that they don't commit a robbery while they're on that probation. And so this is, you know, sort of a spectacular violation of that probation. You know, if you weren't facing, well, our guidelines here were 7 to 23, so I could revoke your probation and send you to prison, but based upon the credit you had before, and you've been sitting on my probation violation warrant for now more than a year, you've got about 18 months credit with me on these files. So I don't see any need to impose any further time in these cases. So I'm not going to revoke the probation and re-sentence you on the underlying felonies here. We're just going to discharge your probation as unsuccessful and give you credit for time served. And because I'm not giving a prison sentence, that'll be 365 days jail, credit for 365 days that you've already served. Of course, any fines and costs are still owed that were previously assessed. We're not doing a new judgment today, but so you know, I think we'll probably end up doing a remittance order to the prison in your Emmett County case. So you want to do what you can to get those paid off. You're going to be in prison long enough, it sounds like, that you're going to want to have unfettered commissary without stuff being taken out to pay your fines and costs. So if you're able to do anything with that, or family members, you want to encourage them to get those things paid down. Since I'm not revoking the probation, just discharging, there's no appeal rights at this time then. So Mr. Joliet, Mr. Joliet, we're gonna just discharge you as unsuccessful and give you time served. So whatever you got going over there, you can take care of over there. Do you have any questions for me, sir?
no, sir.
Okay, good luck to you.
Thank you.
7111 and 25-7112. Counsel, you want to state your appearances, please?
Melissa Goodrich, Bergen County Prosecutor.
And James Gilbert here on behalf of Ms. Williams.
All right, looks like we're here for sentencing on possession of heroin, habitual second with a 0 to 21 range, and absconding habitual second with a 10 to 28 range for the guidelines. Have you had a chance to review the report and recommendations?
Yes, we have gone through them. We have no additions or corrections or scoring challenges.
Okay, any from the people?
Your Honor, the kids score, PRV 7 was scored at 20 points for the possession, but not for the absconding. So I would ask that PRV 7 also be scored for 20 on that one. Because we're being sentenced here today on 2000.
Okay, Mr. Gilbert.
So my argument would be that they were separate in time and independent of each other, and as that it does not be scored as 20.
The absconding was absconding from the first case.
Oh, that's right. Well, let me see here. The so the possession is a 2021 offense date, right? So,
Yes. But she wasn't picked up and arraigned on it until September 14th, or maybe July 14th, 2025.
Oh, when did she fail to appear? In 2025 or in
No,
2021?
yeah, in 2025 on the prelim after she,
Oh, okay, so she wasn't arrested until 2025.
yes.
So arrested in 2025, then absconded, and then has been convicted in 2026 for the possession and the absconding. All right, score the appropriate value if the offender was convicted of multiple felony counts or was convicted of a felony after the sentencing offense was committed. So for the possession, which occurred in 2021, she certainly has enough subsequent felony convictions. Wait, does she? Yeah, in June of, okay, February 17th, I'm looking at conviction 21 of 23 in Genesee County. A plea of February of 2026 and a sentencing disposition of March 17th. And that was was lying to a peace officer 1 to 4 crime investigations. Is that a felony or misdemeanor? That's misdemeanor. Okay. So she's got the possession of methamphetamine there. And then the absconding. Okay, so in the possession of heroin case, it's properly scored at 20 points based upon a subsequent conviction for possession of methamphetamine and a concurrent or subsequent conviction for the absconding. In the absconding case, that was committed in 2025. September. There's no subsequent conviction. So is it a concurrent conviction? I think I would consider the possession of heroin a concurrent conviction when she's pled and sentenced at the same time. Those are in fact concurrent convictions. She's convicted concurrently. And the only time gap is a result of her absconding. So I think that the possession of heroin does count as a concurrent conviction, but that would only be 1, not 2. So I would score in the absconding prior record variable 7 at 10 points, not 20, but I'll grant you the 10, Ms. Fitch.
Thank you.
And that increases the total PRV to 70 points. And on the F grid, does that change the range? No, it would remain on the E grid. So the range would remain the same. All right, Mr. Gilbert, anything you want to say on your client's behalf?
Yes, Your Honor. She has an ongoing case, Genesee, correct? And I just want to make sure I have my counties correct, where she's waiting, and part of that the program that they have for her is that she has to get what's done here resolved. She'll be going back to Genesee, assuming that this works out, and then she would be waiting for a bed for treatment. I believe this was all reflected. I know the court agrees the PSI, so I'm probably just repeating what the court already knows, but that and then she'd be getting a bed at treatment, and that program is supposed to last for approximately 3 months. The thing that would be over her head in that case is if she doesn't complete treatment, Genesee will be sending her to prison. So what I'm asking in this case is that I just don't believe any additional time from today. I know the recommendations for a year. I would ask that the court sentence her to time served, then let Genesee take over and get her into treatment. And again, if she fails there, then Genesee will be sent her to prison. So that, and like, as I'm saying, I don't think an additional jail, unless the court is inclined to send her to prison, which I hope is not the case, additional time in our jail probably would serve no purpose. So I would ask the court to give her this opportunity. I know she doesn't have a good history of when it comes to the absconding, but I think she has enough hanging over her head with, if she does not make Genesee happy, she is going to prison. So there's a great motivational there, and I'd ask the court to take that into consideration. Thank you.
All right, thank you. Ms. Williams, you don't have to tell me anything today, but you're welcome to. Is there anything you want to tell me or no?
Yeah, I have been using for a long time, and I mean, I guess no matter which way you cut it, I know my life will change from now forward. Sorry, no, but so I mean, I don't know. I know that it counts on me, like, well, it's me, so I'm gonna, you know.
All right, thank you. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor, thank you. Just going over the timeline here, on January 25th of 2021, the defendant was found in possession of heroin in Sheboygan County, but not picked up on that warrant, as we discussed, till July 14th of 2025. Back on June 17th of 2025, the defendant was in possession of methamphetamine and lied to a police officer in Genesee County. On June 23rd of 2025, the defendant was again in possession of methamphetamine in Genesee County, and also possession of a controlled substance less than 25 grams. And then on September 9th of 2025, she failed to show for her preliminary examination in Sheboygan County. Shortly after that, she also failed to show for her preliminary examination in Genesee County. She was later found and transported to the Genesee County Jail, so the case is resumed, and then also with the new absconding case. The defendant is 31 years old. She was 17 at the time of her first arrest. She now has 7 felonies and 15 misdemeanors. She's been to jail already 13 times. Probation has been tried 6 times. Her current status is that she's on probation in Genesee County for those 2 drug cases. She's on probation in the 67th District Court for retail fraud with a show cause hearing scheduled this month. She has a warrant for possession of methamphetamine, a count organized retail crime, and a possession narcotic under 25 grams in the 70th District Court in Saginaw, and also currently a failure to appear warrant for retail fraud out of the 52nd District Court. She's unemployed with an 8th grade education. The guidelines for the possession of heroin are 0 to 21 and absconding 10 to 28. The absconding is discretionary consecutive. The PSI is recommending 12 months jail for both charges, with credit of 236 days and 233 days. The people are recommending, since jail has already been tried 3 times, to not do the 12 months jail again, given her criminal history. She, if we look through her criminal history, has had steady theft and drug crimes since 2017 in multiple counties in Michigan and some even in Florida, along with her absconding behavior in this case, as well as a pending case, including a failure to appear right now. The absconding should be at a minimum of guideline range. I'm asking the court to sentence her to 19 months consecutive to the drug case, with credit for time served on the drug case, but 0 credit on the absconding in 19 months. I think that would address the sentencing goals of deterrence as well as punishment, since rehabilitation does not appear to be a realistic goal at this time, given her decisions and actions. Thank you.
All right, thank you.
Commentary, vo. This is one of those courtroom moments where you can see the balance judges have to strike. On one hand, the defendant has an extensive criminal history and repeated failures to comply with court orders. On the other, nearly every offense discussed revolves around addiction rather than drug trafficking. Notice how the judge acknowledges both accountability and the devastating impact of substance abuse before deciding on a sentence. That's an important distinction in criminal court. What do you think? Should repeat drug possession offenders receive more treatment opportunities, or should repeated violations eventually lead to harsher punishment? Let us know your thoughts in the comments.
Well, Ms. Williams, You know, when you've got, here we've got a defense attorney and a prosecutor both doing their jobs really well because they're both telling me true things about you. All those things that they both said are all true, right? Because people are a mix of good and bad. And it's rare that you encounter somebody that's all good or all bad. And you've already, I don't need to tell you what drugs is going to take away from you. You've lost kids. You've lost, I don't know if you've had much employment. You don't have much education. You've had some crummy things happen to you. You've done some crummy things. You've got some mental health struggles as well. Drugs have contributed to all those things. So drugs is just robbing you of every single good thing that's available in this world. So all the stuff that happened to you in the past, you can still have some good things in this world, but not with drugs. You already walked that path long enough that there's nothing there but darkness for you. The prosecutor's right. You got a bunch of prior felonies. You're absconding in this case. You got guidelines in both of these that would let me send you to prison. Discretionary consecutive. But you know, what I didn't hear, what I don't see when I look at this history is deliveries. They're all possessions. Not just that they were pled to possessions, they're all charged as possessions. So, you know, it's tough to find judges, and it should be hard to find judges who are real excited about sending people to prison for possession. I've done it sometimes. I don't like it. I've done it. But when I've done it, it's exactly this, where somebody's just accumulating so many felonies, there's nothing left to do. So you're in an environment now where even possessing drugs, given your lengthy history, as a judge, hang on, you don't want to do that. As a judge thinking about whether prison's appropriate. I'm not sending you to prison today. I just want you to know you're in the ballpark now where you're close to going to prison for just possession. In this case, I've got a 2021 traffic stop. Miss Williams is a passenger. She's got a personal use amount of heroin with her. It's charged in 2025. She's arrested in 2025 on it. Then she fails to appear and gets an absconding charge as well. There's no indication of more criminal charges or convictions after the date that she absconded. So I think there's no aggravating factors for that absconding that would cause me to think about consecutive sentencing. So in the exercise of my discretion, I'm going to do concurrent sentencing and not stack the cases. Mr. Gilbert gave some good reasons why time served would make sense. And I even wrote some notes to myself that there's some reasons why that might make sense to allow you to begin the New Paths program in probation in Genesee. You know, the prosecutor made a reasonable pitch for why you should go to prison, and I'm not doing that. Where the guidelines, especially in the absconding, are 10 to 28 months, it's kind of hard to justify, you know, a downward departure. Or shoot, even lower end is tough to justify given your history. So I think the recommendations from the Department of Corrections, I think, are pretty measured.
This hearing wrapped up with a sentence that reflects both accountability and restraint. The judge declined to impose a prison sentence, instead ordering a 1-year county jail sentence with substantial credit for time already served, allowing the defendant to move toward treatment after completing the remaining time. Throughout the hearing, the court carefully weighed criminal history, repeated probation violations, addiction, and the possibility of rehabilitation before reaching its decision. It's a reminder that sentencing isn't based on one fact alone. It's the totality of the circumstances that guides the outcome.
And pretty proportionate. So I'm going to adopt those. And in both these files, order that you serve 12 months in the Sheboygan County Jail, give you credit for 236 days served in 7111, 233 days served in 7112. And those will run concurrent with each other. In 7111, There's state cost of $68, crime victims assessment of $130, and court costs of $350. In 7112, there's state cost of $68 and a crime victims assessment of $130. I will indicate, I mean, you've already got credit for a bunch, so I don't know whether you'd be eligible for these other programs, but to the extent you've got more time to do in Sheboygan County Jail and would qualify, I'll put on these judgments. I have no objection to Ms. Williams participating in either CBT programming or trustee program with credit if the jail determines her to be eligible for those. And Ms. Williams, if you wanted to file an appeal in either or both of these cases, you'd have to file an application. If you wanted a lawyer, you'd have to ask me within 6 months. So we're going to hand you some pieces of paper about your appeal rights. We're going to ask you to initial 1 copy in each file, so we have a record we gave it to you. The other one's for you to fill out if you want to take an appeal. So bottom line, it's 1 year. You're sitting on what, about 9 months credit? Almost, not quite, about 8 months credit. So you got a couple more to do if you get good time, and then you go off to Genesee, and good luck. Good luck to you on probation. Okay. Somebody zooming in on a fire tablet, which might be Miss Young. I think.
I thought she was gonna be here when I talked to her today, but